Hi, everyone. Harry here to talk about the big decision denying Mark Meadows' effort to remove his case from state court to federal court. This is big for Meadows and big for the entire case because there are 5 people, and there will be 6 with Trump trying to remove. Meadows had by far the best shot, plus just the way that Judge Jones decided it seems to indicate the others really will have no shot. All right, so just to set the table again, Mark Meadows gets up, testifies, takes a big risk. Looks like that risk did not pay off. Gives a kind of bromide version. Oh, I'm just doing chief of staffy kind of stuff, setting up phone calls and the like. And the court, very lawyerly, but very definitive. Why I say very lawyerly is the court's Judge Jones starts out saying it's a low burden for sure and we know that from the 11th Circuit, to get removal, but it is a burden and Meadows hasn't met it. And as he goes through each point where he could have been saying things like, it's clear Meadows was doing this for campaign reasons, and it's clear that has nothing to do with his chief of staff duties. He as much as said it, but he kept it couched in the legal terms of, therefore, I find Meadows has not met his burden of showing, et cetera, et cetera. Now, the big kind of analytical linchpin of the whole thing is his finding that the act involved. That really came up. Is it the overt act charged in the indictment? And recall that he had asked for briefing. What about if one act is okay or part of his official duties and the other is not? He cut through that analysis or that quandary by saying the act is the one he's been charged with, and that is associating with the RICO conspiracy. And that means, undertaking efforts to have Trump, at least as alleged, undertaking efforts to have the election for Biden stolen. But he didn't even put it that way, and he didn't need to. The way Judge Jones focused on it is all this stuff, and in particular, some overt acts that he dissects individually, like going down to Cobb County, Georgia, like participating in the phone call with Raffensperger, the famous one, like his interactions with Michigan, are plainly for the campaign and not for the government. And he's just made clear the federal government has no constitutional responsibility for overseeing or influencing anything about a state election. So he basically rejected the gambit Meadows tried to play when he testified, saying, it could potentially concern Trump, and so Meadows had to know it to be able to brief Trump. He accepted essentially the characterization of what was going on from the state, at least as alleged, and he didn't have to show that Meadows did X, Y, or Z, but rather just that the activities that are the sort of heart of the indictment have to do with the Trump campaign, trying to help the Trump campaign. That is not what a chief of staff's supposed to do, or within the description or outer perimeter of a chief of staff's duty. He talked about the Hatch Act, which, remember, precludes federal employees from engaging in political activity. He didn't actually use it to the extent that the DA was hoping. Not that it matters. The DA is definitely dancing tonight, and Meadows, sobbing in his beer. But what they said about the Hatch Act is it really shows, it's illustrative of the basic point that working on a campaign, trying to help out a campaign, that's just not part of a federal officer's duties. And it just reinforces the conclusion that the court is drawing that, this is not what a chief of staff is supposed to do. So the court cuts through the kind of more abstract or bland presentation. I was just doing that, or the other, setting up meetings, etc., and goes to the core as alleged, finds, as is overwhelmingly clear, that he's doing campaign activities. Doesn't even, as I say, have to show that it's criminal or whatever, but he's working on campaign. That's not what chiefs of staff do. Forget about removal. All right. A small point that's a silver lining for Meadows is he has a right of appeal now to the 11th Circuit. And the judge in Fulton County, I think, is aware of the very tricky possibility that they begin to try Mark Meadows only for the 11th Circuit to reverse that decision and say Meadows should be in federal court. Doesn't seem very likely to me. Nevertheless, if it happened, it would be like a total constitutional puzzle and a disaster. He's here, supposed to be in federal court, and yet he's sitting having evidence against him in state court. And he's already had jeopardy attached. What happens then? I think the judge in Fulton County, who will be conscious of that problem, almost certainly will not start the case, at least as it involves Meadows. If it keeps to the pattern that the judge wants, Chesbrough and Powell in an early case, everybody else in a second case, that second case won't go until Meadows' appeal has worked its way through, and also Trump. Trump's going to wait till the last minute. That'll be the end of September 30th, to move for removal. He almost certainly will lose if you give this, even cursory look. Talk about stuff that's not part of official duties of the federal government. His are much more demonstrably so. But he'll have the right to appeal, etc. So that, I think, will augur, a fair delay until the second trial, if indeed that's the one that concerns Trump, because there are scenarios where there's a third and a fourth and a fifth trial. But in any event, the trial that involves Meadows and Trump and the people who've sought removal probably won't happen till their appeals work their way up. Otherwise, it's a catastrophe for Meadows. He had, kind of very adroitly skipped through and avoided trouble in the January 6th committee. He had cooperated, but only in half measure with Smith, but enough so that he wasn't considered to be a co-conspirator, said what he needed, not the other. But not making a deal with Smith means he didn't try to make a deal with Willis either. So he goes in there fresh, and his strategy for sure is to try to get removal and immunity. Immunity is now off the table, as the court said, because he's not finding removal, so I'm not even going to deal with it. So Meadows is now, almost made it to the end of that solemn course, but then fell. I don't know who's old enough to remember the Wild World of Sports beginning, where the guy takes an incredible tumble down the ski slope. That is now Mark Meadows. He's completely exposed to the Fulton County charges. They think that he may have committed perjury on the stand, which would make it very hard even to let him cooperate. Plus, his time for it may have passed. In any event, at very best, if he cooperates, he gets a lot less than he could have before, and he may not even be able to. And that means, what's the point of even trying to cooperate in the federal system if he's going to be facing such a huge sentence in the state court? And, it won't happen until the appeals run, but I think the train's in the station, and it's just going to come barreling out straight at Mark Meadows, and I really don't see how he can get around it. And the odds of serving a serious sentence in Georgia State Court have now multiplied tremendously for the former chief of staff and arguably the guy with the second most culpability for the whole coup and January 6th constitutional crisis. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.